The first thing I saw was the concrete. Not a notice. Not an email. Not a polite message in the homeowner portal with a subject line like important community update. Concrete. 2 barriers sat across the entrance to my driveway, wide enough to make the point and heavy enough to make the point permanent, at least for the afternoon. They were the kind of objects that did not need to explain themselves. They had already made a decision on my behalf. I stopped at the edge of the street and looked at the space where my car normally turned toward the house. The driveway was still there. The garage was still there. My front door was still visible between the trees. The only thing missing was the part that made all of those things practical, a way to reach them with a vehicle. I got out and walked closer. The barriers were not temporary cones. They were not a contractor's tape line. They were concrete, weather-colored and blunt, sitting exactly where a car needed to pass. For a few seconds, I tried to imagine a reasonable explanation. Maybe a utility emergency. Maybe a damaged pipe. Maybe a truck had been scheduled and the crew had placed them while they worked. There are many things a homeowner will explain to himself before he accepts that an organization has deliberately put a wall across his driveway. Then I saw the small HOA notice attached to one of the barriers. It referred to a boundary disagreement. It said the section connecting my driveway to the main road crossed community property. The language was confident. The document was not. It did not identify a recorded map. It did not point to a specific easement or a county filing. It did not explain why a boundary disagreement had turned into concrete in the middle of my afternoon. I called the number on the notice. The person who answered told me the board was reviewing the matter and that the barriers would remain in place while the review continued. That sentence had the smooth shape of a process. It also meant I could not park at my own home. I took photographs from several angles. I photographed the notice, the barrier, the driveway edge, and the approach from the main road. I wrote down the time because I had learned that memory becomes less useful the moment 2 people disagree about what happened. The barriers did not move. And somewhere inside the HOA's version of the property, my driveway had become conditional. Before that afternoon, the driveway was the least interesting part of my house. I used it without thinking. I turned in, parked, carried groceries through the garage, and left again. When a delivery arrived, the driver could reach the front door without asking a board, a manager, or a committee whether the route was community approved. The route existed, and that was usually the end of the conversation. That is what makes an access dispute difficult to describe to somebody who has not experienced one. You are not fighting over an abstract line on a map. You are trying to explain why a line you have crossed every day has suddenly become a question mark. The HOA's notice treated the problem as a boundary issue. My body experienced it as a parking problem, a delivery problem, a work problem, and a question about whether the house I owned could still be used in the ordinary way. I parked on the street that evening. It was not impossible. That was part of the trap. Nothing about the situation looked dramatic enough to justify the feeling it created. I could still walk inside. I could still make dinner. I could still tell myself that a board meeting would solve everything. But a house with uncertain vehicle access is not the same house. I began listing the small consequences. A package that normally arrived at the door would now have to be carried from the street. A guest would have to find a safe place to stop. If I needed to move something heavy, the distance changed from a few steps to an awkward arrangement involving a curb and a driveway that I could see but not use. The larger consequence was harder to measure. If the HOA could block the route because it had decided the strip was community property, what would happen the next time somebody disagreed about the boundary? Would the barrier return? Would the same argument affect a future buyer? Would I have to explain to somebody touring the house that the driveway existed physically but might be unavailable administratively? I did not have answers. I had a barrier and a notice that used the word community as if the word itself were a deed. That evening, I sent the HOA a short written request. I asked for the document supporting the obstruction, the specific property line the board was relying on, and the process for restoring access while the issue was reviewed. I did not threaten anybody. I did not tell the board what I thought of its judgment. I asked for the authority in writing. The response was polite. It was also incomplete. The first answer came from management rather than from a board member. It said the matter involved a disagreement over the boundary and that the HOA was acting to protect community property. It advised me not to move the barriers because doing so could create additional liability. That last sentence was the part I read twice. The barriers had appeared without my permission. Now I was being warned that touching them could become my problem. The word liability has a useful effect in an HOA email. It makes a decision sound cautious, even when the decision has already placed the risk on somebody else. I was not being invited to a discussion about access. I was being asked to accept a physical restriction first and wait for an explanation later. I replied and asked 3 questions. What recorded document established that the driveway connection was community property? What authority allowed the HOA to block the route rather than mark the disputed area or schedule a survey? What temporary arrangement would allow me to access my home while the boundary issue was reviewed? The answer did not address the first 2 questions directly. It said the board had consulted its advisors and that the matter would be handled through the association's normal process. The temporary arrangement was not described. That was the moment I understood that the word review could mean 2 very different things. To me, it meant somebody was checking the documents. To the HOA, it seemed to mean the barrier stayed until the board felt finished. I printed the notice and the email thread. I saved the photographs in a folder and added the date to every file name. It felt excessive. It also felt less excessive than trying to remember the sequence 6 months later. I had no desire to become the person who spent every evening arguing with a board. I wanted to use my driveway. But there was a difference between wanting a quick answer and accepting a quick assumption. The HOA had made a physical decision. If I responded only with frustration, the discussion would remain a matter of competing opinions. If I responded with documents, the discussion might become narrower. I started looking for the papers that came with the house. The first workaround was simple enough to describe and awkward enough to live with. I parked on the street and walked in. If I had something heavy, I carried it farther. If somebody came to the house, I explained where to stop. The workaround made the HOA's decision look less serious from a distance because the house remained occupied and the street remained open. That is how access problems become easy to minimize. The inconvenience is distributed across dozens of small moments instead of one dramatic emergency. A person sets down a box at the curb. A visitor turns around. A delivery driver calls. A homeowner checks the weather before carrying something from the car. The property still functions, technically. It just requires permission from a problem that did not exist the day before. I asked whether the HOA would let a car pass during specific hours while the review continued. The answer was no. The board did not want to create an arrangement that might be interpreted as acknowledging an access right before it had finished reviewing the boundary. That answer told me something important. The HOA understood that access mattered. If it were only a decorative route, temporary use would not threaten its position. The refusal was not about safety or construction. It was about control. I wrote that down without adding an opinion beside it. The next message from management asked residents not to approach the barriers or interfere with the area. It was a general notice, but it made the situation feel more public. The barrier was no longer only between my car and my driveway. It had become a visible statement about who was allowed to decide what happened there. I kept the photographs and the messages together. I also kept a record of what I had not received: no complete plat exhibit, no survey, no recorded access instrument, no schedule for a review, and no explanation of why the route had to be closed immediately. Absence is not proof. But when a board relies on a document, the absence of that document is a reasonable question. The folder was getting thicker. The driveway was still blocked. That was enough reason to stop trying to solve the problem inside my own head and let somebody trained in property records read the paper. The next few days had the strange rhythm of a problem that was urgent to one person and administrative to everyone else. I parked on the street. I carried things farther. I watched visitors slow down at the barriers and then looked toward the house for an explanation. The barriers became part of the view, which was probably the point. A concrete object is a very efficient notice board. The HOA's messages continued to use careful language. The board was reviewing historical information. Council had been contacted. Residents were asked not to interfere with community property. The matter would be addressed when the review was complete. None of those sentences told me when I could drive home again. I asked whether the board would permit a temporary opening while a surveyor or records office confirmed the boundary. I suggested a documented access arrangement that could be revisited once the records were clear. I offered a path that did not require anybody to admit they had been wrong before the documents were examined. The answer was another version of no. It did not say no. It said the request could not be accommodated at that time because the HOA had to protect its position. The distinction mattered. A temporary opening would have reduced the harm while preserving the board's ability to review the claim. Refusing the opening meant the board was choosing to keep the harm in place while it protected an argument that had not yet been proven. That was when I began to separate the physical problem from the emotional one. The emotional problem was that somebody had put concrete across my driveway and expected me to remain polite about it. The physical and procedural problem was that the HOA had not shown the document that gave it the power to do so. The second problem was the one I could work with. I kept a short log. Date, contact, response, consequence. I noted that the driveway remained blocked and that the HOA had declined temporary access. I wrote down which questions had been answered and which had been moved into another sentence. I did not know yet whether the board was wrong. I knew only that confidence was not the same as proof. And I knew that if the dispute continued, the first person who could produce a clean chronology would have an advantage. I called the law office of Teresa Nguyen, PLC, after I realized I was spending more time trying to understand the HOA's explanation than the HOA was spending explaining it. The first conversation was not dramatic. Nobody promised a courtroom victory. Nobody told me the board was going to be embarrassed by Friday. The questions were practical. What did the notice say? Where exactly were the barriers? What documents came with the property? Had the driveway been used this way before? What had the HOA said in writing, and what had it said only on the phone? I sent the photographs and the email thread. I sent the title packet I had at home, the plat materials I could find, and the notices. I included the dates because the sequence was already becoming the story. The team asked for the complete set rather than the page I thought looked important. That was useful. Homeowners tend to search for the one sentence that proves their side. Lawyers need to know what appears before and after that sentence, who recorded it, and whether a later document changed its meaning. I learned that the first job was not to win an argument with the HOA. It was to identify the instrument that controlled access. That distinction made the problem feel smaller, even though the barriers had not moved. The firm explained that it would review the title documents, plat maps, and historical records filed with the county recorder's office. At that point, I did not know what the records would prove. I had a folder, a blocked driveway, and an organization telling me to wait. I added the firm's request to the log. The folder developed subfolders: photographs, notices, emails, property documents, historical questions. There is a particular kind of calm that comes from putting a problem into labeled folders. It does not solve anything. It does make the problem stop moving around in your head. The HOA had treated the driveway as a piece of disputed community space. The records might show whether it had ever been that simple. The first review found something that was more useful than a dramatic contradiction. It found a gap. The HOA notice referred to a map or exhibit, but the copy attached to the notice did not include the full page. A line was visible. A label was visible. The part that explained how the line connected to the driveway was not. It was possible that the missing section was unimportant. It was also possible that the missing section was the reason the page had been copied that way. We did not assume either one. The firm requested the complete exhibit and compared it with the recorded title materials. The question was not whether a red line appeared somewhere on a map. The question was what the line represented, who had recorded it, and how it related to the route from my house to the main road. That is the difference between looking at a map and reading a map. The older plat map became the object I kept thinking about. It was not a magic document. It did not contain a sentence saying, "The HOA may not put concrete here." Maps rarely provide that kind of courtesy. What it did was preserve a layout from a time before the current argument. It showed the access route in relation to the property. It gave the investigation a fixed point. The board's position was broad. This is community property, so access can be restricted. The plat's question was narrower. What was this route established to do, and what property did it serve? A boundary dispute can be made to sound enormous. A route on a recorded map has to be located, interpreted, and connected to other documents. That work is less exciting than a board accusation, which is exactly why it is useful. The firm did not tell me to rely on the map alone. It used the map to decide what history to request next. That became the first real curiosity loop of the investigation. The old map suggested the HOA's label was incomplete. The next document would have to show whether the access had been established, transferred, reserved, or altered over time. The barriers remained in place while we looked. The plat map could show a route, but it could not tell me what the current board believed that route meant. That was why the historical sequence mattered. An old map can be used in two opposite ways. Somebody can point to a line and declare that it settles everything. Or somebody can treat the line as a starting point and ask what later documents did with it. Counsel took the second approach. We compared the map with the title material and the records that followed it. The work was slower than looking for a single winning sentence. A route can be drawn for access, drainage, utilities, a future road, or a parcel that was later divided. The record has to be read in context. That was also why the HOA's cropped exhibit bothered me. The missing section might have made the board's interpretation stronger. It might have made it weaker. Without the full page, neither side could honestly claim the map had been settled. The firm requested the complete exhibit and kept the request narrow. It did not ask the board to provide every document ever created in the neighborhood. It asked for the document the HOA had relied on when it placed concrete across my driveway. The answer took time. While we waited, I began to understand why people lose property disputes by arguing the wrong size of question. I had started with, "Why did you put barriers here?" The HOA answered with a general statement about community property. Council brought the question back to the route, the recorded history, and the physical consequence. If the access had been established decades earlier, then the board had to explain what changed. If nothing changed, the boundary disagreement was a reason to investigate, not a permission slip to block the entrance. The records did not make the situation exciting. They made it precise. Precision is usually less satisfying than anger in the first 5 minutes, but it holds up better after the first 5 emails. The county recorder's office held the part of the story that the HOA's notice had skipped. Historical records are not written for dramatic effect. They are written by people who assume somebody years later will need to know what a line, a parcel, or a reservation meant. The pages may be plain. The sequence is not. The firm compared the older plat with title documents and historical filings. One document gave the root context. Another showed how the access had been carried forward. A later HOA exhibit used the phrase community property in a way that sounded broader than the older record it was supposed to describe. That was the contradiction. It was not that the HOA had found a single sentence proving it could do anything it wanted. It was that the board's current statement did not explain the older chain that made the driveway usable in the first place. Council explained the issue in a way I could understand. A property rights question is not answered by asking which side sounds more certain. It is answered by identifying the controlling documents, locating the root, and checking whether later rules actually changed what those documents established. The explanation lasted a few minutes. It was not a lecture. It was a decision tree. If the access had been lawfully established decades earlier, and if it was essential to using the home, then the HOA could not treat a boundary disagreement as a complete answer. It would have to explain the recorded basis for the restriction and defend the physical obstruction it had already created. The review confirmed that the driveway access had been lawfully established decades earlier and was essential to the property's use. That was the point at which the dispute stopped being a question of who was louder. It became a question of whether the HOA would change its position after seeing the history. The firm made a reasonable proposal. Restore temporary access while the documents were reviewed. Provide the complete exhibit. Discuss the issue through council rather than leaving concrete in place as a placeholder for a conclusion. I agreed to that approach. It was the first time I made a deliberate choice not to solve the immediate problem myself. I could have moved the barriers. I could have hired somebody to move them. I could have called the police and tried to turn the afternoon into a question of trespass. I could have stood in front of the board at a meeting and asked which member had decided that my driveway was now a public experiment. None of those options would have improved the records. The firm advised me to leave the barriers alone and keep the communication documented. That advice was not satisfying in the way a dramatic answer is satisfying. It was satisfying in the way a lock on a file cabinet is satisfying. It kept the next mistake from becoming mine. We sent the HOA a narrow request: restore temporary access while the dispute was reviewed. Produce the complete exhibit the notice referenced. Identify the recorded instrument supporting the community property claim. Communicate through the appropriate representatives so the discussion stayed attached to documents. The request did not ask the board to apologize, did not ask anyone to admit bad faith. It offered a way to pause the physical harm while the legal position was checked. That distinction mattered because a reasonable request creates a choice for the other side. The HOA could open the route temporarily and review the history. It could provide the complete record and narrow its claim. Or it could keep the barriers in place and put its refusal in writing. The answer came in the third form. The HOA repeated that the strip was community property and declined to restore access while the disagreement continued. The wording was polished. The decision was not abstract anymore. The barriers remained because the board had chosen to keep them there after receiving a request for a temporary solution. That written refusal changed the shape of the dispute. Before it, the HOA could describe the barriers as a temporary measure during review. After it, the record showed that the board had been given a reasonable option and had chosen continued restriction instead. I did not celebrate. I still could not park at home. But for the first time, the HOA had contributed a document that could be answered rather than a general statement that could be repeated. The refusal was not a confession. It did not say the board was trying to interfere with my property. It said the board believed it had the right to protect community property and that access would remain restricted while the matter was evaluated. That is why language matters in a property dispute. A sentence can be calm and still create a consequence. The HOA had now made three things clear. It knew access was blocked. It had been asked for the recorded authority behind the restriction. It had been offered a temporary way to reduce the harm while the records were reviewed. It chose to keep the barriers in place. The firm's response did not overstate the point. It did not call the board corrupt. It did not claim that one map settled every possible legal question. It put the refusal beside the older documents and asked the narrower question again. What authority allows the HOA to do this to an essential access route? The board's phrase community property had started as a shield. On paper, it was becoming a statement that needed support. The practical effects continued. I parked on the street. I carried items. I watched the light change across the barriers. That last detail sounds sentimental, but physical objects have a way of collecting time. The longer the barriers stayed, the more normal the abnormal arrangement threatened to become. I also started thinking about the property as a future transaction. A buyer would not care that the board's emails were written politely. A buyer would ask whether the driveway worked, whether it could be used without a board vote, and whether a boundary disagreement could return with a new set of barriers. The issue was not just restoring the entrance for me. It was preventing the uncertainty from becoming part of the house. The firm prepared the formal demand. The formal demand was not long because it did not need to be dramatic. It stated the access position. It described the concrete barriers and the practical loss of access. It attached the title documents, the plat materials, the historical records, the photographs, and the relevant HOA correspondence. It included the written refusal because the refusal explained why the barriers were still there. The demand asked for immediate removal and restoration of full access. It also described the consequences of continued interference. That was the point where the folders became a position. Every document had a job. The photographs established what the obstruction looked like. The notices established what the HOA claimed. The title and plat materials showed the route in context. The historical records supplied the older sequence. The written refusal showed that the board had continued the restriction after being offered a reasonable temporary solution. None of those items was a magic key. Together, they made the HOA answerable to something outside its own description of the problem. The tone stayed measured. The record was doing the shouting. We sent the demand to the HOA board and its council. Then we waited. Waiting is an underrated part of a property dispute. It gives people time to choose which version of their own statement they can defend. It also gives a homeowner time to imagine every possible outcome, most of them less useful than the documents already assembled. I knew the access record was strong. I did not know which response would arrive first, or whether the board would decide that removing the barriers was easier than defending them. The barriers were still in the driveway. The response window passed without a dramatic announcement. There was no board member standing in the street with a tape measure. There was no neighborly showdown. There were emails, internal review, and the quiet administrative pressure that appears when an organization realizes its first explanation has been turned into a document packet. The HOA's council had to look at the same materials the board had summarized more generally. A boundary disagreement could still exist. A disagreement did not automatically answer the question of who could block the route while the dispute was unresolved. That distinction forced a second review inside the HOA. The board had started with a physical action and a broad phrase. Now it had to defend the relationship between the phrase and the records. If the access had been established decades earlier, the board needed more than a belief that the route crossed community property. It needed a basis for restricting an essential use of the home. I was still the person who could not drive into his own driveway. That kept the story from becoming an abstract exercise in paperwork. I carried a box from the street and set it down at the garage. I moved a delivery around the barrier. I explained the situation to somebody who asked why the driveway was closed. Every explanation sounded longer than the original event. The simplest version was also the most accurate. The HOA had placed concrete barriers across the entrance because it said the strip was community property and the records were being reviewed. The listener usually asked the next question. Can they do that? I stopped answering that question from instinct. I said the issue was being reviewed and that the important documents were the title, the plat, and the historical record. It was not a satisfying answer, but it was a safer one than pretending a homeowner can settle a property rights dispute in a sentence. The board's next move would show whether it wanted to defend the barriers or find a way to remove them without turning the dispute into a longer fight. The cost of the delay was not one large bill. It was a collection of decisions that became harder because the driveway was unavailable. I changed where I parked. I timed trips around what I could carry. I watched deliveries more closely. I thought twice before asking somebody to come to the house because I did not want to explain the barrier to another person who had no reason to be involved. None of that was a legal conclusion. It was the operational cost of a physical restriction. The value question was quieter. If I had decided to sell, the access issue would have had to be explained. A buyer would want to know whether the route was recorded, whether the HOA could block it again, and whether the resolution was permanent. The property could be worth the same on paper and still feel less secure in a transaction. That is why access disputes are not solved simply by saying, "You can walk around. A home is not only a structure. It is the system of ordinary routes that lets the structure function." The HOA's written refusal made that system visible. The board had been offered temporary access while the documents were reviewed and had declined. The refusal did not create every consequence, but it made the continued consequences a choice rather than an accident. I kept the log current. Each entry was short. Barrier remains. Access unavailable. Request sent. Response received. Records under review. The list was not dramatic. It was useful. If the discussion later turned into a disagreement about how long the obstruction had lasted or whether I had asked for a temporary solution, the dates would answer without requiring me to sound angry. The firm also kept the language measured. That helped. If every email had described the board as malicious, the HOA could have made the conversation about tone. The point was simpler. The barriers were there. The access was essential, and the documents did not support the board's broad explanation. The waiting week was becoming a test of which side could remain specific. When the HOA council reviewed the packet, the argument became more specific. The question was no longer whether the community had an interest in a boundary disagreement. The question was whether that interest authorized the exact action the board had taken, placing concrete barriers across a driveway that connected the home to the main road. That is a smaller question, but smaller questions are often harder to avoid. The firm kept returning to the same sequence. The access route had been established long before the current board. The route was essential to use of the property. The HOA had restricted it based on a broad community property claim. The board had declined temporary access after being asked to review the complete records. The more precise the sequence became, the less useful general language sounded. The HOA could still disagree with the interpretation. It could request more information. It could ask for a survey or a formal clarification. What it could not do easily was pretend the physical restriction had no consequence while those steps occurred. The negotiation began with a practical objective: remove the barriers and restore full access. The future mattered too. If the agreement only moved the concrete for 1 week, the dispute could return under a new notice. The resolution needed to address future interference, so the access question did not restart every time a board member read a different map. That did not mean the HOA had to confess that every part of its boundary concern was imaginary. It meant the board had to stop treating an unresolved disagreement as permission to block the route. The social pressure stayed quieter than people expect. Some neighbors wanted the issue gone. Some repeated the phrase community property because it sounded official. Others did not know enough to take a position and preferred not to become part of a dispute involving concrete, maps, and attorneys. That was fine with me. I did not need a crowd. I needed the person responsible for the decision to read the documents. The negotiation did not resemble the kind of scene people write when they want a legal story to feel exciting. There was no table slam. No one announced that the HOA was finished. The conversations moved through council, each side measuring what could be agreed without creating a second problem. The first term was obvious: remove the concrete barriers and restore full access. The second term was less visible but more important: address future interference. The HOA could not solve the immediate problem and leave the same authority claim available for the next board, the next management company, or the next boundary disagreement. The records gave the negotiation a center. David was not asking for a favor from the board. Council was asking the board to stop interfering with an access route that the reviewed documents showed had been lawfully established and was essential to the home's use. I was asked whether I wanted to push for litigation. The honest answer was that I wanted the driveway back. A lawsuit might eventually produce a public ruling, but it would also produce months of cost, delay, and a new kind of conflict with people who lived nearby. Choosing a negotiated resolution was not the same as giving up. It was choosing the result that solved the practical problem fastest while preserving the record that made the solution possible. The HOA had a way to end the dispute without publicly declaring that the board had misunderstood the property. It could remove the barriers, restore access, and agree not to interfere in the same way again. That option became more attractive when the alternative was defending a physical obstruction against a historical document chain. The tone of the communication changed. There was less discussion about whether the driveway felt like community space and more discussion about what the record supported, what access had to be restored, and how the parties would describe the resolution. In a neighborhood dispute, language can preserve dignity. The concrete still has to move. The proposed resolution had to work in the physical world. Removing one barrier while leaving the second in place would not restore access. Allowing a temporary opening without addressing the authority claim would leave the same dispute waiting behind the next meeting agenda. A statement that the HOA intended to respect the records would sound positive and still leave too much room for interpretation. The useful terms were concrete. The barriers would be removed. Full access would be restored. The parties would address future interference, so the same restriction could not return simply because a new board member preferred a different reading of the boundary. Those terms did not require the HOA to agree with every sentence in the homeowner's file. They required the HOA to stop using a disputed interpretation as a reason to physically block the route. I asked what would happen if the board wanted a later survey or a formal clarification. Counsel explained that a future review could happen through the proper process. It did not need to begin by cutting off essential access and asking the homeowner to prove, from the street, that the house could still be used. That was the practical line running through the negotiation. Questions could be reviewed. Access could not be treated as disposable while the questions were open. The agreement also had to describe the outcome clearly enough that a future manager would not have to reconstruct the entire dispute from old emails. A good resolution does not only satisfy the people in the room. It leaves the next person fewer opportunities to misunderstand what was decided. By then, I was no longer hoping for a dramatic admission. I wanted a route that stayed open and a record that explained why. The HOA had one last choice: keep defending the barriers, or accept a solution that restored the property without forcing everyone into months of litigation. Within days, by the end of the week, the HOA agreed to remove the barriers and restore full access. There was no ceremony. One day the concrete was there. Then it was not. I watched the entrance open in stages. First the space between the barriers. Then the clear line from the street to the driveway. Then the ordinary movement of a car turning into a place it had always been expected to reach. It is difficult to explain how unremarkable that movement looked and how much it meant. The driveway did not become more beautiful. The garage did not change. The house did not acquire a new feature. A restriction disappeared, and the property became usable in the way I had understood it before the board introduced its disagreement. I drove in slowly the first time, not because the route was difficult, but because I wanted to be sure the resolution was physical, not merely verbal. The approach was clear. The car entered. I parked. That was the moment the dispute moved from a document problem back into daily life. The resolution also prohibited similar interference in the future. That term mattered because the first barrier had not been caused by a temporary inconvenience. It had been caused by an authority claim. If the claim remained untouched, the concrete could return under a different explanation. The future protection closed that loop. I did not get a courtroom ruling with a case number. I did not get a dramatic apology from every board member. I got the route back, a negotiated protection against the same interference, and a record that explained why the result made sense. That was enough. The records did not make the HOA careless. They made the HOA specific. Before the review, the board could point to a boundary disagreement and say community property. After the review, it had to account for the title documents, the plat map, the historical filings, the essential use of the driveway, and its own written refusal to restore temporary access while those records were being checked. That is the quiet power of a complete file. It does not need to sound angry. It only needs to make each claim answer the next document. The result was simple. The barriers were removed within days or within a week, without filing a lawsuit. I avoided the cost and delay of a drawn-out court battle, and the agreement addressed future interference. The story is not that every HOA dispute can be solved in a week. The story is that physical access should not be treated as a minor inconvenience while an organization decides which document it wants to rely on. When an HOA blocks essential access, the first step is not to match its confidence. It is to identify the property instruments, the recorded plat, the historical sequence, and the exact decision that caused the restriction. A boundary disagreement may be real. A broad label may sound official. Neither one replaces the document that actually governs the route. I still think about the first afternoon sometimes. The concrete barriers were the most visible part of the problem, But they were not the deepest part. The deeper problem was the assumption that a confident administrative statement could become a physical fact before anybody checked the record. The old plat map did not win the argument by itself. It gave the investigation a place to start. The title documents, historical records, photographs, written requests, formal demand, and measured negotiation carried the rest. And the next time somebody says a driveway is community property, the useful question is not whether the sentence sounds certain. The useful question is, where is that written down? If I had to reduce the experience to a few practical habits, I would start with the ones that help me most. Photograph the physical condition before anything changes. Keep every notice and reply in date order. Ask for the complete document, not the excerpt that happens to support somebody's explanation. Separate what the board says from what the recorded property instruments establish. And when access is essential, describe the practical consequence clearly instead of assuming everybody understands it because the driveway is visible. Those habits do not guarantee a quick resolution. They do something more modest and more valuable. They keep the dispute attached to facts while the other side decides whether to keep escalating it. They also give a professional a usable starting point. A clear photograph, a dated notice, a complete map, and a short chronology are easier to evaluate than a month of frustrated explanations. In this case, that small discipline helped turn a blocked entrance into a question the HOA could not answer with a slogan. Property rights, access rights, easements, and HOA authority vary by jurisdiction and by the governing documents for a specific property. This narration is for general information and storytelling purposes only. It is not legal advice and does not create an attorney-client relationship.